The number you have reached, 911, has been changed to a non-published number.
Next, we have evidence. And in evidence, we go back to Joyce against Commonwealth from Virginia Court of Appeals. Because VSIN, NCIC, these various reports that are used to show people's records, as well as their, other information about them, are routinely used and relied upon by the Virginia State Police in regular course of business. It can be introduced into the trial under the business record exception. Basically, in this case, the prosecutor wanted to introduce a prior conviction of the defendant. It was under a different name. He introduced the VSIN, which was prior record of the defendant, which had all the aliases the defendant had used in the past. He introduced that and used the VSIN to show that the conviction was actually the defendant. And the defendant objected to that, and the court said, no, that's fine. It can be done. There is a business record exception here. Okay, now let's talk about what specifically applies to the appellate courts. We get Alford against Commonwealth again. This is from the Court of Appeals. Again, it's the same thing we had before. If the defendant agrees to an erroneous jury instruction, he doesn't get to appeal it in circuit court or in the Court of Appeals. Approbate and reprobate, as we all know. You're not allowed to do that. And again, the ends of justice don't apply unless the defendant affirmatively proves that some element of the crime was not proven. Now, here's something I'd never seen before: the fugitive disentitlement doctrine. Reed against Commonwealth. Kind of like almost a modern day version of outlaw reading, except they don't take all your stuff. When a convicted individual becomes a fugitive while his appeal is pending, the appeal is to be dismissed. There are three things which must be proven to invoke the fugitive disentitlement doctrine. Of course, the petitioner's got to be a fugitive. There's got to be a nexus between the appeal and the petitioner being a fugitive, and the dismissal must be necessary to effectuate the policy concerns underlying the doctrine. Okay, obviously in this case, the defendant was a fugitive. Otherwise, the Commonwealth would never filed this motion. Then we go on to the nexus requirement. The nexus requirement is actually an evaluation of whether the appellate's status as a fugitive impacts the appellate process. And basically they say by failing to produce himself so he can be subject to the decision of the appellate courts, the petitioner establishes that nexus between his fugitive status and the appeal. I've got to say that's tenuous. I mean, anyone who's done an appeal, at least in Virginia, knows that your client doesn't come with you to court when you argue it. Your client doesn't do any of the paperwork or research. Basically, he's out there with you sending him a letter every couple months going, here's what's going on, here's what's going on. That's as far as it really goes, his involvement. While, yes, at the end, if the defense wins, the client would have to be present for his new trial, or if the defense loses and the defendant is a fugitive, he can't be brought in to serve the time he was supposed to serve. So that is a problem, but it doesn't really stop the appeal process. The policy, the third prong, policy behind the doctrine is the fugitive can't have decisions of the, when he's a fugitive, he can't have the decisions of the courts enforced against him. It's inequitable to allow him to flee custody and still avail himself of the courts. So it's an inequity if he gets access to the courts. And it's also necessary to discourage escape and to encourage voluntary surrenders. They also, at the very end, say this is a doctrine that should be employed when there is absolutely no lesser sanction that can be applied. and they said, well, there's no lesser sanction here, so it must be employed. I'm pretty sure most of you out there can think of lesser sanctions that could be applied. Uh, you know, contempt of court, maybe. You know, but well, so anytime your clients disappear on you, which any of you who've done appellate work, you've had clients disappear on you before. Remember, prosecution, well, not prosecution, the Attorney General's office can file that fugitive disentitlement doctrine motion, and your appeal is done, dead in the water.
And finally, what we've got is a habeas decision. And this is Pestel against Ballard. It comes from the Fourth Circuit, and somebody is petitioning for a writ of habeas corpus based upon the interstate agreement on detainers, because they're saying that the states violated the anti-shuttling provision, or the trial before return provision. Now, basically what this means is he's saying that under the interstate agreement on detainers, which each state has passed their own version of, which are generally pretty close to each other, if someone is being held in one state, prison in one state, and another state issues a detainer on him, that state can then get him brought to, say Virginia. Tennessee's got him in prison. Virginia issues a detainer. He's brought to Virginia for trial, and Virginia's supposed to hold him until the entire trial process is done, and then return him to Tennessee. And in this case, apparently, whatever state he was being held in, he got brought to Virginia, and before the entire trial was done, he got sent back to the state, and then came back to Virginia to finish the trial off. And he's complaining that that's clearly illegal under the statutes, and there should be a habeas because of this. And Fourth Circuit basically says, nah, that's not a recognizable reason for habeas, and shuts it down. And that's about it. Thank you, ladies and gentlemen, for listening to what's now turning out to be a 3-day CLTV. Hope it was useful and entertaining. Well, probably wasn't entertaining, but hope it was useful. And next week, hopefully it'll just be a 1-day CLTV. Have a good week.